Greetings, I'm trademark attorney Josh Gerben, and I would like to talk about what does use in commerce mean as it relates to a trademark application. In any trademark application, the U.S. government asks a very important question. Are the goods or services that the trademark represents being used in commerce? If you answer yes, and you are not meeting the legal requirements of use in commerce, you have just created a loophole by which any subsequent registration that you achieve could be canceled at any time because an incorrect or fraudulent statement was now made in the application. So let's talk about what use in commerce means. It means that your goods or services that are identified in the application are available for sale or are being offered. If you're offering an informational-based website, clearly there's not any sales. It's just that it's out there and being offered and being consumed by individuals or people that are not family and friends. And most of the time, this has to cross state lines. So it can't just be your next door neighbor. It has to be someone in a different state. There's something called the Interstate Commerce Clause that gives Congress the ability to regulate interstate commerce, and that's how we get federal trademarks. So it's just important that the commerce cross state lines. So the reason this is so important is because a lot of people think that by registering a domain name, registering a company name, or just putting up a splash page, a coming soon thing on your website, that this is enough to meet the use in commerce requirement, and it is not. Again, this is so important because if you do say that you're using the trademark in commerce, but you are not, then you have made a fraudulent statement in your application and it can be canceled. Any registration you get can be canceled. You can get the certificate, it can be taken away. One of the reasons I find that clients like to say yes, they're using the trademark in commerce is because it avoids a filing at the end of the process. If you file the trademark application and say that you are only intending to use the trademark, then what happens is once the government reviews your application, they will come back and require that you now prove that you're using the trademark in commerce. That filing, if you're working with my firm, costs a flat legal fee of $195 to make and a $100 per class government filing fee. So it adds some fees on the back end of the process. The reason the government allows you to submit the trademark before you begin using the goods or services is because you should have the ability to reserve the name. We want to say, you have an idea and you want to bring it to the market, but you don't want somebody else to jump in front of you. So okay, you can file the federal trademark application, get federal rights on the trademark, but before that registration can be issued, you have to prove that you're using the goods and the services. I hope this helps clarify some of the process. If you have any other questions, please feel free to give me a call.